My name is Andrew Mwansa. Now, recently, the 25-member Technical Committee on Constitutional Amendments handed over its report, including a draft constitutional bill to President Hakainde Hichilema State House, after what the government described as a nationwide consultative exercise that yielded approximately 11,860 public submissions. Shortly thereafter, the National Assembly of Zambia resumed consideration of Bill 7. The bill was reactivated and has now progressed to second reading, following communication from the executive requesting Parliament to resume the deliberations. Proponents praised this development as a renewed participatory constitutional review, but critics, including the Oasis Forum and the other civil society organizations, argue that the process merely resurrects a bill previously struck down by a Constitutional Court of Zambia judgment in the Munir and Celestine Mukandila versus the Attorney General. The court had ruled that the process leading to the bill failed to meet the constitutional requirement for broad-based public consultation and the Constitution of Zambia. Tonight on Costa Cross-Examination, we interrogate the judgment in the Munir, Zulu and Celestine Mukandila case versus the Attorney General, which has become a major point of national debate. You're joining us live on channel 271 on DSTV and channel 20 on GoTV, but remember that you can be part of the program by getting to our comment section on our Facebook live stream. We are streaming this program on the Diamond TV Facebook page. It's called Diamond TV Online. Tonight, we are privileged to be joined in by constitutional lawyer Mehluli Malisa. We discuss the Celestine Mukandila and Munir Zulu case versus the Attorney General, what it really means, and the position that the executive arm of government has taken to insist that Bill 7 must proceed. In fact, Bill 7 is already before the floor of the House, and it has progressed to second reading. And earlier on today, we did see the Select Committee sitting and collecting and receiving submissions from the members of the general public. Counsel, good evening. Thank you so much for joining us on Costa Cross-Examination tonight.
Good evening, Andrew. Good evening, viewers. Thank you for having me.
Let's begin off with the technical report that the technical team did submit to the president. The team did announce to the president that they collected a massive 11,860 submissions in a very short space of time. In fact, the spokesperson of the committee, Dr. Landon Banda, mentioned that this is the second highest number that we've ever collected when it comes to the collection of submissions in our country. Must we commend the technical team for having done an amazing job in ensuring that they collect as much as possible in terms of the views of the people?
Well, that's one way of looking at it. So, yes, they say that they received 11,860 submissions within a space of about 12 days. And according to their report, the bulk of the submissions came via the online platform, which is their website. So that is a commendable feat. But I think in this conversation, what would be important is not the quantity of the submissions, but rather the quality of the submissions. So I think, given the time frame that they were working with, that's a lot. Yeah. That's a lot. But now, from that perspective, it will be interesting to know, of these 11,860 submissions, where were they coming from?
Across the country, that's what they say.
Where? How many came from Eastern? How many came from Southern? How many came from at district level? How many came at provincial level? How many came at national level? right? That would be a more useful statistic rather than just clumping them together. You get what I mean?
Do you see this number realistic, owing to the fact that other committees that have existed before this committee would be given a time frame of over 2 years to 3 years to have to collect views, but still they would come up with a number that is not as massive as this, especially owing to the fact that they were only given a very limited time frame to work, around. Do you see this number realistic, or do you think it's cooked up?
I won't say it's cooked up. I'm not in a position to say that. But given the complexity of the task and a constitutional amendment process being predominantly a qualitative rather than quantitative process, so I would think that just saying that we had 11,860 submissions is not a useful statistic. I can tell you that if you go to the technical committee report, the 2016 one, right, which led to the current constitution, the Anil Silungu Technical Committee was quite thorough, even in their report, how they reported. For example, they would say that we held so many district-level meetings. So many people attended that meeting, right? Out of that many people, or they say 80 people attended this meeting. Out of 80 people, so many people submitted orally. So many people submitted documentary, right? So then it gives you a very detailed statistics to say, oh, okay, so in Lusaka province or Lusaka district, 100 people attended the meeting. Out of those 100, so many submitted. Or if they were online, where are they coming from? Are they coming from Lusaka? Are they coming from Chienge? Where are they coming from? So then it makes us now have, if you want us to have a quantitative analysis, because if you give us numbers, then we'll start breaking down those numbers from a statistical point of view, because you want us to use statistics. So if you give me, you've got 11,800, very good, nice. Where are they coming from?
But does it paint a picture, into your mind, Council, that in this very short space of time, less than a month, we could collect as many as this? Does it paint a picture to you that our people are interested in ensuring that we have changes to our constitution?
Of course, people would be interested. I mean, that is the reason why the court ordered that you should have widespread consultation, because the constitution, it should come from the people. It's the people's document. So definitely people would be interested in what is happening with their constitutional document. So going back to the quantity of the submissions, right? The stats or the statistics need to be useful for one to analyze, because you can say you have 11,000 submissions. What if all 11,000 submissions came from one person, or they just came from one area of the country? Right? Then that figure becomes useless as an analytical tool, right? What would be useful is for you to break it down, to say, okay, we got so many. From youth groups, we got so many. From this. All this should be sitting in that report, but it is not there.
Yeah, let's quickly get to the technical committee itself. Obviously, the setup of the technical committee was a consequence of the judgment that came through, from the Constitutional Court in the Munir, Zulu and Celestine Mukandila case versus our Attorney General. One of the issues that the Constitutional Court ordered was that, and I'm reading the Munir Zulu case here. It says that we order that the respondent complies with the spirit of the Constitution by ensuring a people-driven process led by an independent body of experts in conducting wide consultations with the people. The executive arm of this government did comply with this, and that committee was set up. From where you sit, do you completely feel that the committee or the president or the executive arm of government complied with this very specific instruction that the committee must be independent? Do you agree that this committee was independent?
No.
Why do you say so?
First of all, you have to look at how the committee was appointed. Okay, the committee was appointed by virtue of Article 93. Is it Article 92? You can check there if you have the Constitution. And Article 92, I think it's Article 93. Just check. I think it's 92. Hold on. Let me check. If you have the Constitution there, it's 92.
I have the Constitution with me,
Yeah, it's Article 92, which gives the president power.
Yeah, it says the president shall perform with dignity, leadership, and integrity the acts that are necessary and expedient for or reasonably incidental to the exercise of the executive authority.
That's 92.
Yes.
93?
93 goes on to say decision or instruction of the president shall be in writing under the president's signature. The signature of the president on an instrument shall be under public seal.
Okay. So they were appointed under Article 92, E and F. Right. So if you read what Article 92 says.
Yes. 92E says appoint persons as are required by the Constitution or any other law to be appointed by the president. F says appoint persons as are required to perform special duties for the executive. G confers honors.
Just there. F, it says to perform special duties for the executive. Right.
Yes.
So who was the technical committee working for? The technical committee was working for the executive. Right. So in as much as they say they are independent, by virtue of the statutory power, the constitutional power that appointed them, which means that they were performing executive functions on behalf of the president, right? So which means that they were functionaries of the president, right? Now, their independence, there is no law which was passed which says that the technical committee would not be under the direction of anyone, right? So you get what I mean? It's not there, okay? If you look at other provisions like maybe provisions to do with the judiciary or to do with the Attorney General, for example, the Attorney General 177 is appointed by the president, right? But the law explicitly states that the Attorney General shall be independent in their functions and shall not be under the direction of any authority or what. So the law has spelled out their independence. Even the judiciary, judges are appointed by the president. But judges, the law says that the judiciary shall be independent. The judges shall not be under the direction of anyone. So this aspect was lacking on the part of the technical committee. Now, by virtue of them being presidential appointees, which means they were serving at the pleasure of the president, right? So the president appoints the technical committee and can dissolve it anytime, right? You know, who has power to appoint has power to disappoint.
Yeah.
So from that standpoint, what critics have been saying, and if you hear people talking about a legal framework, what they were saying is that there must have been a legal instrument or an act of parliament that stakes the committee's independence and says, okay, fine, committee, you are appointed by the president, but you are independent in your functions, in the way you design your scope of work and everything. There is nothing when it comes to this technical committee that shows that they had that functional and they had that autonomy in terms of their operations, in terms of anything. It was not explicitly stated in any law or in any legal instrument. It just said that they were going to come up with their own procedure, right? Yeah. That's all. That's all it says.
But are you confident that, look, this is a team that comprises of different, people that comes from different walks of life.
Yes.
There were civil society organizations present there. There was the Law Association of Zambia, young people, and nearly everyone was represented in that technical committee. Not everyone, but a reasonable number of people, were represented from that particular technical committee. The composition itself, it doesn't give you hope that the work that this committee undertook is that of integrity?
No, I am not here to question the integrity of the people who were on the committee. I think some of the people on the committee are people of high integrity, and they're people that I respect so much, okay? So I cannot question their integrity or anything. But to say that the technical committee was representative of, you mentioned LAS, you mentioned other organizations, that is not true. That is not true, okay? The people who were appointed, they were appointed in their personal capacity. They were not appointed in institutional capacity, right? If you want to understand what institutional appointment means, right, have a look at, which one can I pick? if you look at the NCC Act of 2007, National Constitutional Conference Act, or you look at the one that led to the infamous Bill 10, there was what they called the National Dialogue Forum Act. If you want, you can open. It stated the composition of the what? Of the committee or those attending that forum, right? So the way it stated it, it would say 1 or 2 representatives from the Law Association of Zambia, 1 representative from media, from MISA Zambia, right? That way, that becomes an institutional appointment.
But when these recommendations, these recommendations from the last meeting the president had at State House with various civil society organizations, which Laz was a part of, and what I'm meant to believe that part of the resolution of that meeting at State House was that the CSOs who are present will recommend individuals that, could be on this committee. That's my understanding, and that's what, in fact, the ruling party says, that there was, the CSOs were asked to recommend, individuals to sit on this technical committee. So they were not handpicked by the president.
Well, you and me were not in that meeting, isn't it? No, we were not there. So it's who says, he says, right? But if you are going to put something down in an act of parliament or in the law, it becomes easy for all of us to cross-check, right? Now, let me open this this act, National Dialogue Constitution, Electoral Process, Public Order and Political Parties Act, number 1 of 2019, right? Section 5 of this act, it was an act of parliament, right? Section 5 of this act, open this. The side note says composition of the forum. So the composition of the forum is sitting inside the what? The act, right? You and me can come here. It says the forum consists of all members of parliament and the following members appointed by the secretary to the cabinet. It says who should appoint, right? A, 2 representatives from each political party with representation in parliament. 1 representative from a political party which is a member of the Forum of Political Parties which are members of the Zambia Center for Inter-Party Dialogue. 2 representatives each of A, the Zambia Conference for Catholic Bishops, the Council of Churches in Zambia, the Evangelical Fellowship of Zambia, the Islamic Council of Zambia, Independent Churches Association of Zambia, Seventh-day Adventist Church Association, Apostolic Church, Islamic Church, then 1 representative from Office of the President, Office from the Clerk of the National Assembly, 2 representatives of the Judiciary, 1 representative from the... Right. The Act specifies who should be in that committee, right? This is an example of an institutional appointment. You get what I mean? Yeah. There's a difference between an institutional appointment and a personal appointment. So me, if I'm appointed as Mehluli Malisa to be on the technical committee, yes, I'm a member of LAS, but me being a member of LAS does not mean that I have the authority to represent LAS. Do you get that? You get the difference?
Yes, I get where you're going. I get where you're going. Does the law prescribe how appointments to a constitutional process committee must be appointed? Does the law prescribe that this is what we must do as we are, appointing a committee to go out there and collect views? Is there a law that prescribes that?
There is no law. So then
why are we faulting this?
There is no law. That is why, if you followed me correctly, I said that when you're talking about the independence of a process, you have to pass a law that will give it independence, right? As long as you have not passed a law that will ring-fence or reinforce that independence, then we can't talk about independence, because you are appointed under presidential powers to appoint people for executive functions, right? That is the enabling provision, right? That is the power that is the law that was exercised by the president. That is the law that was invoked.
And that law, there's nothing wrong with what happened here.
No. Speaking strictly from a legal point of view,
no law was broken here.
No, there was no law which was broken. There was no law which was broken. If you're speaking under Article 92, the president has got power to appoint anyone to do anything to help him do his executive functions. So, under Article 92, it's fine. The president can appoint anyone. If he can appoint you and me to be on a commission for load shedding, it doesn't matter. The president has got powers to do that. And the president exercises his powers under Article 92 to appoint people to help him do an executive function.
You give an example of the National Dialogue Forum and how the composition of the committee looked like. But is it the same as the other commissions that have existed before? Or perhaps what we are seeing today under President Hakainde Hichilema is something very peculiar? In terms of a technical committee.
So the technical committee, we first saw it in 2012, under President Michael Sata. He's the one who appointed a technical committee, which was headed by the Chief Justice. All previous attempts to amend the Constitution had been through the Inquiries Act. The Inquiries Act is an act of Parliament. So the Inquiries Act gives the President power to appoint a commission of inquiry and then to issue terms of reference and things like that. So in 2011, when President Michael in 2012, sorry, it was in 2012. In 2012, when President Michael had appointed that committee, he said that a number of commissions of inquiries had taken place, right? And their submissions were there. They were public record. The reports from Vunga, Mwanakatwe, they were all there, right? So he said, I'm going to get a committee of experts, right? Committee of experts. And these experts are supposed to look at the previous submissions, the previous reports of previous previous commissions, and then come up with a draft constitution. And then from that draft, they are going to consult the people of Zambia, because their mandate was that they were basing their thing on what had been submitted before. So their theory was that they take what had been submitted, produce one draft, and then take it back to the people and ask the people, is this what you submitted? And then the people who submit. That is what happened. So in this case here, because the Constitutional Court said, try and replicate what happened in the TCDZC, Technical Commission drafting the Zambian Commission. They said try and replicate or do something of a similar magnitude. That is why I guess President Hakainde Hichilema appointed the technical committee.
And obviously we did see thereafter that the process began to happen. But what's at the center of debate in the country at the moment, besides the content of the bill and the report of the technical committee, is the Celestine Mukandila and Munir Zulu versus the Attorney General case. The argument there is by the executive and the ruling parties that the Constitutional Court never declared Bill 7 a nullity, it never declared Bill 7 unconstitutional, and never declared Bill 7 illegal. Let's quickly, if I can rush to the case here. I have the case with me, and if I could quickly go to the judgment. The Constitutional Court was very clear, in rendering its judgment. It says, if I could start from 54, it says, we have noted the respondents' arguments that the proposed amendments relate to non-contentious issues. We are not convinced. More as even so-called non-contentious issues can change the Constitution fundamentally. The only way to properly protect the Constitution is to take every amendment process through a wide consultative process with the people at inception. Having considered the Constitution as a whole, in particular Articles 1, 2, 5, 7, 8, 9, 61, 90, 91, 92, and 118, we have come to the inescapable conclusion that the constitutional amendment process cannot be initiated with the without the participation of the people of Zambia through wide consultations. In the absence of any evidence that the initial process undertaken by the respondents meets the expectations of wide consultations with the people as stated above, we are of the firm view that the initiating process lacks legitimacy. Accordingly, we grant the following reliefs. we declare that the decision by the respondent to initiate a constitutional amendment process before undertaking wide consultation with the people goes against the spirit of Articles 1, 2, 5, 7, 8, 9, 61, 90, 91, and 92 of the Constitution. This is a bone of contention, Council. The argument by those that are supporting this bill are stating that what the Constitutional Court ruled is not what most of you are trying to argue. The Constitutional Court never argued or never ruled that this process was unconstitutional. They argue that it just went against the spirit of Articles 1, 2, 5, 7, 8, 9, 61, 90, 91, and 92. As an officer of the court, really, Council, what is the interpretation of this judgment by the Constitutional Court?
Okay, I find that very hilarious, honestly. So you are saying that something that goes against the spirit of the Constitution is not unconstitutional?
That's what
is that what they're saying?
That's what they argue.
So, okay, maybe for the benefit of the people at home and maybe those who might not understand legal terms, or maybe I should explain what it means that an act goes against the spirit of the Constitution, right? So what it means is that something happens that may not violate an explicit or an express provision of the Constitution, right? So there are two things. There's the letter of the Constitution. The letter of the Constitution is the written text, right? Explicit provision. And then there's the spirit of the Constitution. So the spirit of the Constitution is the underlying philosophy behind the constitutional architecture, right? So as they say that the Constitution is a living document, right? That is where the issue of the spirit comes in. So there are a number of provisions in the Constitution, right, which when you read together, they pronounce a certain philosophy, right? For example, I want to give you an example.
Yeah.
The separation of powers. It is accepted that in Zambia, our constitutional order establishes a separation of powers between the judiciary, the executive, and the legislature, right? But if you go to the Constitution, you won't find anywhere where it's written, there shall be separation of powers in Zambia. It's not there, okay? But that concept is part of the spirit of the Constitution. When you read the whole Constitution, the spirit, the separation of powers will come out as a principle. Right. So when the court says that your action was against the spirit of the Constitution, right, they were saying that there is no express provision in the Constitution that mandates public participation. But when you read the Constitution as a whole, especially these articles that they mentioned here, 1, 2, 5, 7, 8, 9, 6, 9 of the Constitution, then you will come to the conclusion that consultation of the public is a prerequisite for you commencing any amendment process. And this is what it means.
And does not amount to breaking the law.
If something is inconsistent with the Constitution, then it becomes a nullity. Article 1.1 says anything that is inconsistent with the Constitution, right? It does not say anything that breaks the Constitution. Does it say that? You can read Article 1.1. It doesn't say that. It says any act, any omission, any undertaking that is inconsistent with this Constitution is void, right? So when the court says it's going against the spirit of the Constitution, what they're simply saying is that it is inconsistent with what we are reading here. As in these articles here, they cited 11 articles. So these articles, when you put them together, they pronounce a principle, right? So what has happened here goes against this principle. It goes against this constitutional norm. So if you go back to Article 1.1, which says anything inconsistent with the Constitution is void. It says, it uses the word inconsistent.
But I think I understand. In short, you're saying
you're saying that Bill 7 did not violate the Constitution. Yes, the court didn't say that Bill 7 violated the Constitution. The court was talking about the process that gave birth to Bill 7. It wasn't talking about Bill 7. Okay? It was talking about the process. Because that is the question it was asked. The people said, this bill, where it came from, it did not come from the people. That was the question, right? And they were saying it is unconstitutional for you to generate a bill alone without the people.
is it right to say unconstitutional, or is to use the very words that the court used here? Because perhaps maybe we're changing everything if we say it's unconstitutional.
Okay. Can something that goes against the spirit of the Constitution be constitutional? Okay, you want us to be technical about this term. Okay, let's go. Can anything that goes against the spirit okay, let's
because others argue, use language but because others argue, counsel, that what the Constitutional Court here says is that the practice has been that you go to the people.
Yes.
But here the practice has not. The Attorney General failed to convince the courts that there was a practice that the Constitution over the years has followed that wasn't followed through here. And so not that there was any specific law that was broken, because when you're going to say unconstitutional, others argue that then you're saying a law was broken. And so here, others argue that the law wasn't broken, counsel. What the Constitutional Court is saying is that the executive process didn't follow through the practice, and the practice is that you go to the people before, a bill is presented to Parliament.
No, that's not what the court said. Let's not put the words into the mouth of the court. The court said,
against the spirit.
Yeah, against the spirit of Articles 1, 2, 5, 7, 9, 12 of the Constitution. The Constitution is the law. So you are going again, and I explained that when you're saying the spirit, you're not pointing at a specific article, but a combination of articles, right? If someone says the spirit of the Constitution, I try to explain this. It's saying when you put together all these articles, they bring out a principle, right? So what the court was simply saying is that this practice that we've been doing has been reinforced by a combination of these constitutional articles. So it is not correct to say for the Constitution to be breached, there must be a specific article that has been breached. So in short, what the court is saying, if you are going against the spirit of this, the principle that the Constitution is bringing, mind you, the Constitutional Court always insists that the Constitution should be read as a whole. You cannot pick apart the Constitution.
So in short, would you agree that the Constitution here was violated?
It's not me, so that's what the court said.
No, I'm asking you, from your interpretation, would you say the Constitution...
From what the court said here. Yes.
Would that amount to a Constitution being violated?
Yes.
Then can this amount to it being treasonous if a Constitution is violated?
I don't know. It depends on how you explain. But my understanding of treason is that treason is trying to overthrow a constitutionally elected government. So I'm not seeing anywhere where someone is trying to commit treason. But what I can say is that when the Constitutional Court says that it goes against the spirit of the Constitution, right? When they say it goes against the spirit of it, it's like you're reading the Constitution on the whole. It means that whatever was happening sits outside constitutional norms. So if anything sits outside the constitutional norm or constitutional practice or whatever word you want to use, right, it means that that act is unconstitutional. That's what it means. Or if you want to use a nice term, let's use the term that is used in Article 1.1 and say the act is inconsistent with the Constitution. Yeah. If you want to say the Constitution was not violated, fine. We'll say the initiation was inconsistent with the spirit of the Constitution.
So let's be clear for the people that this judgment didn't render Bill 7 unconstitutional. It rendered the process to the initiation of the bill. It rendered, this process of having gone against the spirit of these, named articles. So it didn't render Bill 7 in itself as a bill unconstitutional. Is that the correct position of the law?
No.
Of things?
No, it will be incorrect to read it like that. Actually, that is, I don't know what word I can use to bring such interpretation, right? So, if something is unconstitutional, right? If something is, okay, let me use the exact words the court used. It goes against the spirit of the Constitution. In short, it is inconsistent with the spirit of the Constitution.
My question
yes, I want to answer you in context, right? So, if we go to Article 1.1, it says anything which is inconsistent with the Constitution is void. So what does the word void mean? Do you know? The word void means nothing, right? It means there is nothing. Okay, so if the process is void, can nothing produce something? Can nothing produce something? So if we say that the Constitutional Court said that the initiation of the process, the start of the process, right, was against the spirit of the Constitution, right? And we said anything that is inconsistent with the Constitution, according to Article 1.1, is void. It means you take nothing and plant it in the ground. Do you expect a crop to come out?
No, you don't expect a crop to come out.
Because you've planted nothing. So there is no need for us to even say that Bill 7 is not unconstitutional, because Bill 7, where did it come from? Right?
From this process.
The process which the court says is void is inconsistent with the Constitution, right? So I don't understand why someone who claims to be a lawyer would come and sit on national television and say that the process was against the spirit of the Constitution, but the product
is constitutional.
How does that even work?
So let's get back here. So after this judgment, like I mentioned earlier, the consequence was that the president did appoint a technical committee to satisfy, the judgment of the Constitutional Court, and the technical committee went and got those submissions. Do we still render Bill 7, and I would like to use the term that you've used, unconstitutional, when a committee that the court ordered to be established was established, and they went out there and collected views? Do we still call Bill 7 unconstitutional when the executive has followed through the directives of the Constitutional Court?
Bill 7 hasn't changed.
So it has to change.
It's still the same one. It's still the same one. It hasn't changed. So what has changed? What has changed? If it was inconsistent with the Constitution on the 27th of June 2025, and it's still the same Bill 7 that is before Parliament, what has changed?
So are we going against the judgment of the Constitutional Court if we proceed and amend and have sittings around Bill 7?
Yes. In my view, that's my personal view, because the process that gave birth to Bill 7
was unconstitutional,
was inconsistent with the Constitution, according to the court. Right. So, which means any product of that process becomes subject to what? To constitutional voidness. Right. It's void according to void ab initio, from the start. Right. So, what was supposed to happen, in my view, was that the president, in appointing the technical committee, was trying to comply with the judgment of the court.
Yes.
Right. That was correct, because the court said that the consultations should be at the start.
Yes.
Right. Should be at the start, at the initiation process. Right. If you look at this judgment, throughout, it uses the word initiating, inception. Right. At inception. So it means that the widespread consultations are the source of whatever bill you are supposed to take to Parliament under Article 79, right? So we're not talking about Bill 7. Bill 7 was not a product of widespread consultations. That's not where Bill 7 came from. This is where the problem is, okay? Bill 7 did not come from the people. It came from the government, right? And they presented it in Parliament. Then the court said, you were not supposed to do that. What you were supposed to do was consult the people first, right? What the people say is what goes into the bill, right? And then you take that bill now based on what the people have said, and then you bring it to Parliament now under Article 79. Do you get what I'm saying? Right. So this now means that the source of the Constitution or the constitutional amendment are those widespread consultations that you have started. So when the technical committee was appointed, what we expected was that the technical committee would do its consultative process, right? And then come back and produce a report and a draft bill.
which they did.
Which they did, yes.
Which they did. So that draft bill, that one, is the one which is a product of their consultative framework, because they have the evidence and they've put it in a report.
Yes.
That draft bill is the one now the government was supposed to take and gazette. Now they invoke Article 79.
Article 79.
Yes.
But the Minister of Information explained, what's at play here, that the standing orders don't allow for, for you to take the same, to initiate the same bill with the same content. The standing that goes against the standing orders, of Parliament. And so what will happen now is that the recommendation of the technical committee will be used during the sittings in Parliament. Right now, sittings have begun, and so the technical committee is expected to, to be part of those sittings, so that Bill 7 mirrors, what the submissions that they collected from the people. But from your explanation, Council, will Parliament also be, in contempt here if they don't work on this bill that was presented to them by the committee? Because owing to the fact that the standing orders are very clear, when it comes to dealing with a bill that has got the same content, how will this play out, from a legal, point of view? And is it possible to do anything legal here that will still make us proceed with amending Bill 7?
Okay, so I didn't see or hear the minister's explanation, but from what you're saying, it means that the minister agrees that the initial stages of Bill 7 were done without public consultation. The public consultation only happened after the technical committee was appointed, right? That's correct.
Yes.
I'm getting it correctly.
Yes.
Right. So what it means then is that you have in Parliament Bill 7, which was put there without any public consultation. It's still there. It's the same one that they put before the technical committee was appointed. It's the same one. So it means from that time to now, nothing has changed. In as far as we're concerned, nothing has changed, because it's still the same Bill 7 that is being discussed in Parliament.
The Attorney General has petitioned the Constitutional Court to vacate its earlier position on, on this case. Will it change anything? Because what if what you're explaining is what the correct position of the law is, then many agree with you that yes, proceeding with debates in the House with Bill 7 that went against the spirits of these provisions of the law that we are broken, then we'll be breaking the law. But if the petition by the Attorney General becomes successful, then will it render that bill legal or constitutional, if you like to put it that way?
Good. You see, I think we need to be serious when we're dealing with issues to do with the Constitution, right? I'm hearing two things coming. One, that the court did not say that Bill 7 was unconstitutional. So what is the Attorney General cross-petitioning? If the court did not say that the process leading to Bill 7 was unconstitutional, what does the Attorney General seek to vacate? What is he vacating? What is he trying to vacate through the court? My understanding is that the Attorney General has cross-petitioned in a petition which was done by Munir Zulu and Brian Mundubile? Brian Mundubile and Celestine Mukandila, right? They pushed in a petition, right? And then the Attorney General, the government, in their answer to the petition, they decided to tell the court that, after all, your decision in Celestine Mukandila is not the correct decision, okay? So now, if they're saying that decision is not correct, what did that decision say? It goes back to what we're saying. You can't blow hot and cold. You can't eat with both hands. On one end, you are saying that the court did not say the bill was unconstitutional. No one said that. the court said the process was unconstitutional. So what it means is that there's nothing constitutional that can come from an unconstitutional process. That is elementary. You don't even need to be a lawyer to know that. Even in the Bible it's there. A poisoned fruit cannot bear good fruit. Once the fruit is poisoned, that's it. Once the tree is poisoned, that's it. It means that even the fruit is poisoned. So here what you're trying to tell us is that some people are saying that, oh yes, we have a poisoned tree, but the fruit is okay, we can eat it. That doesn't work. That's not how it works in constitutionalism. So if the process is flawed according to what the court said, then the product is also flawed. Simple and straightforward. There's nothing complicated here. It's straightforward. So an order of the court, okay, the rule of law, Andrew, the rule of law demands that you and me respect what the courts say. Whether we agree with the courts or not, the decision of the court is the law. The court is the only arm of government which has adjudicative power. That power was given to the courts by the people through the Constitution. So the courts have had their say. They have said the process is unconstitutional. Whether the government agrees or not, whether the court was wrong or right, that is immaterial. At this point,
what is the consequence of going ahead to amend this Constitution?
What is the consequence of what?
Of going ahead to amend this Constitution when there's that order by the Constitutional Court?
No. The Constitution can be amended as long as you follow what the court says.
Oh, yes, but
the constitutional process.
We've not followed. What is the consequence?
Bill 7 is not the only way to amend the Constitution. I don't know why we are fixated on Bill 7. Because, like I said, the court said, come up with a technical committee to start the process. To start, not package. Now, you are telling me that the Minister of Information said that...
it will be against the standing orders to present a bill with the same content.
But who says it should have the same content?
Well, the terms of reference were mirrored.
They are the ones who engineered it like that. Okay? They are the ones who engineered it like that. There is nowhere where it says that the only amendment to the Zambian Constitution should be according to what Bill 7 says. There is nowhere. Right? Some people who have been submitting against this this whole process were saying, no, you limited the terms of reference, right, to what you wanted in Bill 7. You did not open it to say, oh, people of Zambia, how do you want us to amend your constitution?
Are we going to be in a constitutional crisis if we don't amend this constitution? And in asking that, I want to take you to Article 58 of the Zambian Constitution. It says, Zambia shall be divided into constituencies and wards for purposes of elections to the National Assembly and councils. 2, the number of constituencies shall be equal to the number of seats elected members of the National Assembly. The number of wards districts shall be prescribed. The Electoral Commission of Zambia shall determine names and boundaries of constituencies and wards. 5, it says the Electoral Commission of Zambia, at intervals of not more than 10 years, review the names and boundaries of the constituencies and wards based on this particular provision of the Constitution, because we need to delimit it as a country, because the 10-year interval, is coming. If we proceed,
when did it come?
It's coming in January.
Oh, when was the last time we did a delimitation?
It was in 2016.
2016?
Yes, and then we're supposed to do it again in 2021. And there's a report of 2019, before the Electoral Commission of Zambia. The executive arm of government, and I'll be very specific, your fellow counsel, Counsel Cornelius Mwansa, they considered view that we're going to be in a constitutional crisis if we don't proceed to amend the Constitution because of delimitation. Is that true?
No, it's not. Are we in a constitutional crisis right now?
I'm here to ask questions.
Okay, so we are not in a constitutional crisis. Okay, and if you read Article 58, I want to read it again so that I point out the salient features of this Article 58. Right? Article 58 says, the Electoral Commission shall determine the names and boundaries of constituencies and what, right? It says the ECZ shall do that.
Yes.
Names and what?
Boundaries.
And boundaries. And then it goes to say that shall at intervals of more than 10 years, not more than 10 years, review the names and boundaries of constituencies and what? It says they can review the names and boundaries. Is there anything stopping them from doing that? There's nothing.
There must be a constitutional change if the,
where is it written?
There must be an amendment to the Constitution.
Where is
because
it written?
It's embedded in the Constitution that when these names are changed, it will have an effect on the number of constituencies. Remember that.
Where is it written?
But let me explain. So remember that in our Constitution, it clearly stipulates that there will be 156.
Yes, 156.
Yes. So if there's going to be an increase in the number of constituencies, then it means that there must be an amendment to the Constitution.
Yeah, but you can have a review exercise without increasing the number. You can. The Constitution just says review. Review the names and boundaries. It does not say increase. Okay? So that review process, after a review process is done, a report has to be done. Okay? And the report has to recommend, to say, okay, we recommend that we increase the number of constituencies to so many constituencies, right? And it should give the reasons why. It should give the reasons why the number of constituencies should be increased. And also, that recommendation by ECZ is subject to challenge. You can actually challenge it in the Constitutional Court. Right, let me look at the provision that says that. A person may apply to the Constitutional Court for review of a decision of the Electoral Commission made under this article. This is under Article 58(7). The same article which you are saying that is saying they should. Delimitation does not mean increasing number of constituencies. That is false. That is not true. What is true is that delimitation is an exercise where the Electoral Commission goes on the ground and checks the boundaries of constituencies and looks at various factors that influence constituency boundaries.
Such as population and
geographical size. All those things put together are what determine delimitation. Right. So now, if you are saying review, your review can say increase, or it can say keep them the same, or it can say reduce. Do you get that? Anything can come out of a review exercise, right? So now, if you are saying that if we do not increase the number of constituencies, we are going to be in a constitutional crisis, where are you getting it from? You've come to Article 58 here. It's very straight.
If we don't review, won't that amount to going against the Constitution, where the Constitution is very clear that you must do this after 10 years?
But no one is talking about a review of the constituencies. Are they talking about a review of the constituencies? They're talking about increasing the number of constituencies. Are they saying that this is the review that was done? This is the recommendation, right? This is a conversation we should be having. Where is the report of that review? The Electoral Commission of Zambia is supposed to carry out a review every 10 years, right? Have they done that review in compliance with the Constitution? Have they done it? If they have done it, where is the report? The report is the one which should tell us how many constituencies we need to add, okay, if we have to add. Or a report can simply say, keep it the same number, but just change the boundaries. You get what I mean? The report can say, oh, because people keep moving, okay, it can say, oh, people in Chongwe, a lot of them have moved to Lusaka. So now there are less people in Chongwe. So let's move the boundary like this. Do you get what I mean?
I get what you mean.
Right. So by saying review the boundaries, that is what the Constitution is talking about. Say, go on the ground and check. Are things still the same from 10 years ago? Right? From that point, and also this makes logical sense because a national census is supposed to be carried out every 10 years.
Yes.
Right? So every 10 years we expect to count people in the country, right? And then that report also helps the ECZ to come and what? And do this delimitation exercise, because the census report tells us how many people are in Zambia, where are they, how many are male, what age are they. It tells you all those things, right? It feeds into the delimitation process. So if ECZ goes on the ground and does their delimitation process as per Article 58, then they should come up with a recommendation to say, okay, we have found that there are so many people, right? Ideally, a constituency should have so many people. The ratio of leadership to the number of people that you are representing is so much. So from this recommendation, we've decided to move this boundary, right? the boundary between Chongwe and Lusaka, we're shifting it from airport roundabout, we're shifting it to Silver Rest. The Electoral Commission can do that. And that does not require a constitutional amendment. What requires a constitutional amendment is when you are increasing the number of constituencies. So if the Electoral Commission recommends that you should increase the number of constituencies, then that will trigger a constitutional amendment. Right. But, however, there's a caveat here to say any person may apply to the Constitutional Court for a review of the decision of the Electoral Commission made under this article. So if the Electoral Commission of Zambia recommends, for example, an increase of the number of constituencies, right? Then we have to see this report. Because this report, because it's open to the public to challenge it. Any member of the public can challenge it. So it means that we have to see that report.
I was listening carefully to Honorable Cornelius Moto. He says that actually, as opposed to what so many people are arguing, that the amendment of this constitution gives an advantage to the current administration. In fact, it doesn't do so. What it seeks to do is to be able to close the loopholes that are in the 2016 Constitution, and he makes reference to Article 52, Part 6 of the Constitution, where it says, where a candidate dies, resigns, becomes disqualified in accordance with Article 70, 100, or 153, or a court disqualifies the candidate for corruption or malpractice after the close of nominations and before the election date, the Electoral Commission shall cancel the election and require the filing in of fresh nominations by eligible candidates, and elections shall be held within 30 days of the filing in of those fresh nominations. What the minister was explaining was that they want to protect this country from citizens who would want to apply to participate in the presidential election. Few weeks before the election, they pull, they resign. That means that the commission, will call for fresh nominations, and the president will still stay in office. And they're saying that there could be perpetual people that would be doing that, and this current president will be in office for so many years. That is according to the minister. And so they're trying to put a caveat to stop this and prevent this from happening. And so they must be praised that they're trying to fix some of the loopholes in the Constitution that are dictatorial. I would like to find out from you, Counsel, whether you agree with the arguments by the executive that, look, in fact, we're doing. They're saying that they're very selfless people, that they don't want anything that will ensure that they stay in office for a very long time, but will come as a caveat that will protect even generations to come. That's what they're saying. Would you agree that this constitution must be amended because there are certain provisions that relates to elections that must be fixed before we get into the next election?
Look, constitutional text is not a favor that comes from the executive. Okay, constitutional text comes from the people. Right, whether the executive is doing a favor or not is immaterial here. The court said constitutional amendments must come from the people. That's where they should come from. Right. If they haven't come from the people, then they become a nullity. This is what the court said. It's not me, it's the court. What the court say is the law. Now, in terms of Article 52.6, yes, there is an inherent problem in Article 52.6. We took this matter to court. That's why we have. I remember last time I was here discussing the Gears initiative versus the Attorney General. I am the one who argued that case, and the judgment came out. I understand the inherent problems that are sitting in Article 52.6, and that's why we have courts to interpret these positions, right? We have courts. So you cannot take to court something that has not happened, right? So we've had two elections under this constitution with that same Article 52.6 there. We've had this election twice, first in 2016 and in 2021, and the second election in 2021 led to a change of government with this same Article 52.6 there. How does it become a crisis today? If we had managed to deliver two elections with that article there, then why should it be a crisis today? Are the people who are saying this, do they have intentions of trying to derail the elections? To what end? We have safeguards in the Constitution that are there, that you can take people to court for an interpretation of the Constitution. If it so happens that a presidential candidate, because the Gears case had to do with Member of Parliament, and they were independent candidates, right? So the question that was there, the court answered it, right? Now, if it so happens that someone from a political party standing as president decides to resign or decides to withdraw from the election, my reading of the Gears judgment is that if someone withdraws on their own, the election goes ahead. If they withdraw, right? Okay. Now, resignation is a different thing. Withdrawal and resignation are different. Now, where a political party is concerned, if someone resigns as the president of a political party, right, that political party has to be given a chance to what? To replace, to field another candidate. Now, if I ask you, which political party, which president of a political party would resign their position as president of a political party just in order to frustrate the election? To whose end? To which end? You see, that is why there's a sieving mechanism. That is why ECZ puts in conditions just for you to be nominated as a what? As a presidential candidate, right? For you to be nominated as a presidential candidate in a national election, you need to have at least 100 supporters from each province of the country. That is 1,000 people from all across Zambia. Do you think that a person with such a constituency would do this nonsensical move that you're talking about? So what is there is that the Constitution, as it is, has got a number of safeguards that are there to try and what? And prevent such a situation from happening. But if it does happen, we have the courts. Does Article 52.6 need amendment? Yes, it does. It does. And if you look at what you call the work of the technical committee, the way they have captured Article 52.6, I think it's brilliant how they've done it. But the bottom line is there is no constitutional crisis here. Okay, we cannot start having the whole country panicking on a perceived constitutional crisis, which has not happened. There is no constitutional crisis that has happened.
What must happen to Bill 7, according to you, as an officer of the law at this moment, for posterity? What must we do to Bill 7?
I think I align with the view that when the court said that the process that leads up to Bill 7 is inconsistent with the spirit of the Constitution, at that very point, it means that anything to do with Bill 7 was put to death. Okay, it became a nullity because of what the Constitution says. Right, and I'm basing this on a long-standing legal principle that most lawyers will agree with me, which come from the case of McFoy versus United Africa Company Limited, what they call the McFoy principle. And in that case, it's an English case from 1961. The court said, that's the British Supreme Court, the UK Supreme Court, or it used to be called the House of Lords that time. They said, in their words, exact words, if an act is void, then it is in law a nullity. It is not only bad, but incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. So, if we are saying that Bill 7, the court has already said that it does not follow not Bill 7, the process leading to Bill 7, yes, the source, let me say the source of Bill 7 was against constitutional principles. So what it simply means is that it becomes a nullity, right? And if something is a nullity at law, it means that it's incurably bad. It can't be cured by anything. It's like trying to administer medicine to a dead man. No matter how good your medicine is, no matter how good a surgeon is, if someone is dead, they are dead. you can get the best doctors, they cannot resurrect that person. So at law, those who are saying that Bill 7 died on the 27th of June, this is what they are talking about. To say anything inconsistent with the Constitution is void. That's what the Constitution says. Unless you are making the argument that the court was talking about something else, then the question will ask, then what was it talking about?
In an event that the court vacates that position, it means that then at law will be correct and not in contemptuous if we proceed with...
Yes. An order of court is valid unless and until it is set aside or reversed by the same court, right? You get that. So, as it stands right now, Celestine, Mukandila, and Munir Zulu is the law. That is the position of the law. Until the Constitutional Court changes its position, right? As it stands right now, Celestine, Mukandila, and Munir Zulu is the position of the law as it stands.
Under what circumstances can the Constitutional Court change its position?
Well, if it says that it made its decision per incuriam, like what happened in the eligibility case. I think I remember when you asked me at that time, I remember I told you that I do not agree with the decision of the court, but the decision of the court remains the law until the court changes it. And the court changed it. So now the later position is now the position of the law until that court changes it again, right? So as it stands right now, the decision in Celestine, Mukandila, and Munir Zulu is the position. But if that position changes, then we have to go with the new position of the court. But as it stands, we have to respect what the court said, even if we don't agree with what the court said. But that's what the court says. And that is what the rule of law demands, right? If you and me decide that we're not just going to follow court orders because we do not like what the court said or we do not agree with what the court said.
In an event that the Constitutional Court vacates that position, then the report of the Technical Committee will be an exercise in futility. Because the setup of the Technical Committee was a consequence of the Constitutional Court judgment.
That's what you are saying. But some other sectors are saying, no, it wasn't because of the Constitutional Court. Others are saying, we deferred the bill before the judgment.
That's what the minister says. That's what the minister of
it says they are trying to comply with
that's the
with
chief
the
government spokesperson.
Yeah, but look, then if the chief government spokesperson is saying that it was trying to comply with the judgment, then that's fine. But they haven't complied with the judgment in full. Okay?
So what's the part which is remaining?
Okay, let me read what the court said on page J23, right? Okay, let me start here on J22, paragraph 50.
Yeah.
Right? It says, more importantly, these processes are the source of the Constitution. To demonstrate, the Constitution of Zambia, as amended by the Constitution of Zambia Amendment Act number 2 of 2016, our current Constitution, was birthed, keyword, birthed, by the initial process led by the Technical Committee drafting the Zambian Constitution. It was this process and not the subsequent process under Article 79 of the Constitution that framed the amendments that became the current Constitution, and their legality and legitimacy have never been in doubt, despite the absence of a specific constitutional provision. You get that? 51. In our considered view, the TCDZC process should be replicated or something of similar magnitude. Magnitude means size. Yep. Something of similar size pursued in initiating constitution amendments. Initiating means starting, right? It constitutes what we understand to be the wide consultative process necessary to alter the existing content of the Constitution.
Yep.
State actors should be facilitators of a people-driven process led by an independent committee of experts who should collect views directly from the people and existing records. Only after these proposals are put to the people in a structured manner, such as through district, provincial and national level discussion and adoption, can they be put through the process in Article 79 of the Constitution? So, the technical committee did its work, it submitted its report.
Yeah.
Their proposals have not been put to the people through district and national level discussion, and they haven't gone through an adoption process for them to come to the Article 79 process. So what the court says, it prescribed a whole cocktail of things that need to be done before you go into the Article 79 process. So right now, we are now in the we have jumped into the Article 79 process, but that is not what the court said. It says we follow what the technical committee did. I can tell you what the technical committee between 2013 and 2014 did. It's there in their report, right? Their report is over 1,000 pages long. In their report, what they did was they drafted proposals, right? They drafted what they called the first draft of the Constitution, the amendment that they wanted to do. And then it was sent to all 10 provinces of the country, right? All districts of the country received those proposals so that the people could interact with those proposals and dissect them, right? And then they came back. After that, they went to the people and said, okay, fine, we gave you some proposals. What do you think about these proposals, right? What the feedback that they got from the people is what culminated into a second draft, right? Then they did a second draft, they sent it out again until last time now they sat on their own now with what they called experts. They had a smaller conference which had 300 delegates where they sat now to say, okay, now we're producing the final draft.
Report, yeah.
Right, so what I'm seeing here is that, yes, the technical committee proposed a draft bill. It's there in their report, right? It's there. They said, oh, we've consulted the people of Zambia.
Yeah.
This is what the people have told us, all right? And we have drafted a bill, right? If I'm going to follow what paragraph 51 of the judgment is saying, it means that after the committee submitted the report to the president, that was the first draft of their amended bill, right? That was the first draft. So that bill, in fact, before they even did their final report, when they produced their draft, they were supposed to send that draft around to say, okay, you people, we consulted you. This is what you told us. Is this a reflection of what you said?
Submitted, yeah.
Okay? And then people put their comments to say, oh, no, this is not what we said. We actually said this, okay? And then they edit it now and come up with a second draft, right? Which is based on the feedback from the people. Then after that feedback and all those rounds of things, then they produce a final report with the final.
We didn't have time for that. We didn't have time for that.
Who limited the time? If we were trying to comply with the judgment, this is what the judgment is saying.
Constitutional lawyer Mehluli Malisa, thank you so much for making the time to appear on Costa Cross-Examination tonight to give your position over your understanding in the Munir, Zulu and Celestine Mukandila case versus the Attorney General. We greatly appreciate.
Thank you.
My guest has been constitutional lawyer Mehluli Malisa, who are discussing and interrogating the Munir, Zulu and Celestine Mukandila versus the Attorney General. My name is Andrew Mwansa. Till next time.